Namaskar friends, welcome back to Corporate and Securities Law Compass. Today we are discussing a very powerful and foundational provision under the Companies Act 2013. Section 6. Act to override memorandum articles and other instruments. At first glance, this section appears very short and simple. But in practical corporate law, this provision has massive importance. Because Section 6 establishes the supremacy of the Companies Act over Memorandum of Association, Articles of Association, Shareholder Agreements, Board Resolutions, Contracts, Arrangements, and every other internal corporate document. In simple words, if any provision contained in MOA, AOA, Agreement, Resolution, or any other document is inconsistent with the Companies Act 2013, then such inconsistent provision becomes invalid to the extent of inconsistency. This is the core principle of Section 6. Now let us understand the actual legal concept in simplified manner. Section 6 states that the provisions of the Companies Act shall have overriding effect notwithstanding anything contrary contained in the memorandum, the articles, any agreement executed by the company, any resolution passed by the company, or any other instrument. This means the Companies Act is supreme over internal company arrangements. No company can contract out of statutory obligations. This principle is extremely important in corporate governance. Now let us understand why Section 6 became necessary. A company operates through various legal documents such as Memorandum of Association, Articles of Association, Shareholders Agreements, Joint Venture Agreements, Investment Agreements, Employment Contracts, Board resolutions. Sometimes companies may intentionally or unintentionally insert clauses contrary to law. If such clauses were allowed, companies could bypass statutory protections and regulatory requirements. Therefore, Section 6 ensures that the Companies Act always prevails. Now let us understand this through a practical example. Suppose the Articles of Association of a company state that annual general meeting need not be held every year. Can the company avoid AGM requirements? The answer is absolutely no, because Section 96 of the Companies Act mandates holding of AGM. Under Section 6, any contrary provision in articles becomes invalid. The Companies Act overrides the articles. Now, another important example. Suppose shareholders enter into a private agreement stating, minority shareholders shall never receive notice of board decisions or financial statements. Can such agreement be legally enforceable? No, because the Companies Act grants statutory rights relating to notices, financial statements, inspection rights, and shareholder participation. Any agreement violating statutory rights becomes unenforceable under Section 6. Now let us understand an extremely important principle. The memorandum and articles are subordinate documents. They derive legal validity from the Companies Act itself. Therefore, they cannot override the parent statute. This principle is similar to delegated legislation. Subordinate instruments cannot override the principal law. Now let us understand another practical corporate situation. Suppose a company includes a clause in articles stating, directors can issue shares without board approval or shareholder approval. But the Companies Act requires board approval, shareholder approval, and compliance with Section 62. In such case, the article becomes invalid to that extent, because statutory compliance cannot be avoided through internal drafting. Now let us discuss shareholder agreements. This area becomes highly important in private equity transactions and startup investments. Suppose an investment agreement states certain shareholders can permanently appoint directors without retirement by rotation. But the Companies Act contains mandatory provisions relating to retirement and governance. Then the agreement must comply with the Act. Any inconsistent clause may become unenforceable. This is why corporate lawyers always ensure that investment agreements remain consistent with Companies Act, SEBI Regulations, FEMA provisions, and Articles of Association. Now let us understand another important example. Suppose a company passes a board resolution authorizing acceptance of deposits from public without complying with sections 73 to 76. Can the board resolution protect the company? No, because board resolutions cannot override statutory restrictions. Even unanimous board approval cannot legalize an illegal act. This is a very important corporate governance principle. Now let us discuss the practical importance of Section 6 for company secretaries. A company secretary must always verify whether board resolutions, articles provisions, policy documents, contracts, and agreements are consistent with the Companies Act. If inconsistency exists, the statutory provisions will prevail. Therefore, secretarial vetting becomes extremely important. Now let us understand another legal implication. Section 6 protects stakeholders against oppressive or unlawful contractual arrangements. Without Section 6, majority shareholders may insert unfair clauses against minority shareholders. For example, denying inspection rights, restricting statutory voting rights, eliminating dividend entitlements, avoiding audit requirements. Section 6 prevents such misuse. Now let us understand an important principle from judicial interpretation. Courts have repeatedly held that corporate documents cannot override mandatory statutory provisions. However, if the Companies Act permits flexibility, then parties may create contractual arrangements within permitted limits. This distinction is extremely important. Mandatory provisions cannot be overridden, but optional or flexible provisions may be modified through articles or agreements where the law permits. Now let us understand this distinction carefully. Suppose the Companies Act permits companies to prescribe additional qualifications for directors through articles. Then the company may validly insert such conditions. Why? Because the Act itself allows flexibility. But where the Act creates mandatory obligations, companies cannot contract out. This becomes the heart of Section 6. Now let us discuss another practical example involving dividend. Suppose Article state, the board may refuse dividend to minority shareholders despite declaration. Can such provision survive? No, because once dividend is validly declared, shareholders obtain enforceable rights under the Companies Act. Articles cannot destroy statutory entitlements. Now let us understand the relationship between Section 6 and corporate democracy. Corporate democracy functions through shareholder voting, disclosures, meetings, audit systems, director accountability, minority protection. If companies could override statutory provisions through internal agreements, the entire governance framework would collapse. Therefore, Section 6 acts as a constitutional safeguard within company law. Now let us discuss startup funding arrangements. Many startups sign shareholders agreements, founders agreements, investor rights agreements. Sometimes these agreements contain veto rights, transfer restrictions, exit rights, Board nomination rights. Such provisions are generally valid only if they remain consistent with Companies Act, Articles of Association, FEMA, SEBI regulations where applicable. If inconsistency arises, statutory law prevails. Now let us understand another important example. Suppose articles state that accounts need not be audited every financial year. Can the company avoid statutory audit? Absolutely not. Because audit requirements under the Companies Act are mandatory. Therefore, such article becomes void to the extent of inconsistency. Now let us discuss the phrase to the extent of inconsistency. This phrase is very important. It means only the conflicting portion becomes invalid. The remaining valid portions may continue to operate. For example, if one clause in articles violates the Companies Act, only that conflicting clause may become unenforceable. Entire articles do not automatically become void. Now let us understand why Section 6 is important in litigation. Whenever disputes arise between shareholders, directors, investors, or management, courts often examine whether contractual clauses violate statutory provisions. If inconsistency exists, courts generally enforce the Companies Act over private arrangements. Therefore, Section 6 becomes a powerful litigation provision. Now let us discuss practical compliance lessons. Before drafting or approving articles amendments, shareholders agreements, board resolutions, ESOP policies, investment agreements, financing documents, companies must conduct legal review to ensure consistency with statutory provisions. Ignoring Section 6 can result in unenforceable agreements, governance disputes, regulatory action, litigation risk, and compliance failures. Now let us quickly revise the key principles Section 6 establishes supremacy of the Companies Act 2013. The Companies Act overrides memorandum, articles, agreements, resolutions, and other instruments. Any inconsistent provision becomes void to the extent of inconsistency. Mandatory statutory provisions cannot be overridden through private contracts. However, where the law permits flexibility, companies may create customized arrangements. Now let us conclude. Section 6 may appear small in size, but it is one of the most powerful provisions under company law. It ensures that no company, no board, no shareholder agreement, and no internal arrangement can override the Companies Act. This provision protects shareholders, creditors, regulators, minority investors, and the integrity of corporate governance itself. For company secretaries, corporate lawyers, directors, compliance officers, investors, and startup founders, understanding Section 6 is absolutely essential. Because in corporate law, statutory compliance always prevails over private arrangements. Thank you for watching Corporate and Securities Law Compass. If you found this explanation useful, then like, share, and subscribe for more practical discussions on Companies Act 2013, SEBI Regulations, Corporate Governance, Board Processes, Startup Compliance, Secretarial Practice, Shareholder Rights, and Securities Law Updates. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, The information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.